My lady, my lords, before the short adjournment, I was addressing you on the way in which Iconix put their case on post-sale confusion.
Yes.
Namely, that it wasn't their primary case, but rather it was a narrow focus and had limited ambit. It was made in response to the context of the use of the sign on the Amazon pages. So the judge wasn't being asked, the judge was being asked not that the shoes were presented at any particular angle post-sale that was not provided by Amazon pages, rather that you cannot take into account the Dream Pairs branding and the absence of reference to Umbro. And you can see that clearly from the judgment, my lady and my lords, at 159 and 162. I'll come back to this in terms of the approach you took properly to post-sale confusion, but if you pick it up at 159, for the one's doubt, this is when he's considering the Amazon pages. I would have come to this conclusion that there wasn't a likelihood of confusion, even ignoring the contextual information on the Amazon page for the relevant footwear, including the references to Dream Pairs as a brand and the absence of reference to Umbro. They were the two specific things that were being criticised as being context which shouldn't be taken into account. But he goes over that, I'll come back to that, but goes over 160, I reach the same conclusion in relation to the allegation of post-sale confusion, except the degree of attention would be the same. Potential consumer who saw someone wearing shoes branded with DP logo would not, to my mind, confuse them with the marks. I explained the differences between the sign and the marks, and I consider that these would be apparent to someone with characteristics of an average consumer who saw the relevant goods. I don't think there's a material between this case and the pre-sale presentation, because he's talking at the same thing, namely the same presentation has been seen by evidence of the Amazon pages. Indirect confusion of 161 is irrelevant, there's no challenge. 162, the claimant contains there's a likelihood of post-sale confusion. Consumers who saw people wearing Dream Pair shoes would confuse them with Umbro shoes. The claimant accepts that the average consumer would have the same attentiveness as in the position were they considering buying the goods. Therefore, the only relevance of this point was the context of the buying process, i.e. the various other images and other information on the relevant Amazon page would be absent. The claimant submitted that court should consider how the shoes with a deeper logo would look to other consumers in realistically likely situations. The claimant relies on the image where the boot was muddy, the one my Lord Justice Arnold identified.
No, there were two images relied on, and he's there talking about the second one. And what he doesn't address is the submission that's made in 75.1.5 in relation to the first of the two images, and that's the crux of the appeal.
Well, that's what you say. I mean, it's the allegation. Well, let me finish reading, and then I'll come back. And argues this approach that this approach is permissible because football boots might well be seen on the pitch or on the changing rooms covered in mud. I see the force of this argument in principle. However, it must be remembered that the claimant has to show that the use of the sign, rather than the shape of the boot or anything else, which leads to relevant confusion. I do not consider that a significant portion of the public, having the characteristics of the average consumer, would see the DP logo, even when muddy, so this is the worst case scenario, even when muddy, as more than very faintly to the marks. I do not consider that a significant portion of the public would confuse the DP logo with the marks. This is in the context of post-sale confusion when he's being asked to hypothesize about wearing the shoes in any situation. So what's this whole context of 162? Carrying out the global assessment reached the same conclusion for post-sale as for pre-sale confusion. So that is what he did, and that's something that he was entitled to do. But given the way in which the case was actually put, we say that that is something that he was considering and was entitled to come to in his conclusion. Now, in terms of the scope of the case as it was put to him, could you also, in the same bundle, turn behind tab 6 and go to page 101. This is the submission to appeal document. And at paragraph 53, in relation to the post-sale confusion, in closing submissions, the claimant said, page 101, the claimant said that this was likely to be of limited ambit, and the point only really arises in connection with the arguments that have been advanced about the context contained in the Amazon listings. Given my conclusion at 159, in light of the way the point was put in closing by the claimant, this issue did not arise. He's already found, absent context, he was still found there to be no likelihood of confusion. But in any event, I did conduct a global assessment of the likelihood of post-sale confusion and set up my conclusions at 162. Again, it appears to me that the claimant has raised no issue of law or principle. It is really complaining the court's overall multifactorial assessment. It is something which was a narrow ambit, and it was something he specifically considered. Going back to the particular analysis which he did, could I ask you to turn back to the judgment in terms of the sign and mark comparison in its various contexts? At paragraph, picking up at page 82, giving the structure of the judgment, 132, 133, he does the analysis of what the registered trademark is, the double diamond marks, and he finds them as flat, elongated diamonds, not as tilted squares, something he was entitled to do. 134, he does the analysis of the sign considered as a two-dimensional graphic image, as I said, the paradigm view that was put in the pleaded case, and he does that conclusion and analyses that at 134 through to 136. But then 137, he picks up the signs are not always presented with an Amazon images or actual use on shoes straight onto viewer. Some of the images, because of the angle which it was shot, the sign could appear rather more elongated. Claimants also submitted a view of the sign would not always be able to see the break and so forth. And so what he's doing there is addressing both the Amazon and the actual submission. 138 through to 139, he's dealing specifically with Amazon, and indeed 140 as well. 141, he's dealing specifically with, as someone seeing the footwear itself being worn post-sale in the street, on the football pitch, or in the changing room. In other words, he's looking at realistic, likely scenarios. It appears to me, this is the judge, the sign would again present, as explained above, as a tilted round-cornered broken square with P-form in the middle. It would not appear to a third party on a visual inspection of a pair of elongated sideways setting diamonds. Now, that is something which he was looking at in totality in terms of the post-sale usage, in various environments, realistic environments, and each of those he considered, and he came to the conclusion it wouldn't appear to him that this would appear to be a pair of elongated sideways diamonds, rather be a tilted rounded corner broken square with P-form in the middle. That was a conclusion he was entitled to come to, and there's no error there. My Lord Justice Arnold said the key to this appeal is the error that he didn't look at it but from a particular viewpoint. Well, that particular viewpoint, A, wasn't put to him. There's nowhere was he told in the post-sale environment, there's a particular viewpoint you must look at, which you don't see in the Amazon pictures.
Making that submission, but where did Mr. St. Quentin abandon the submission that was advanced in 71.5 of his written closing?
I didn't say he abandoned it, but the case is put. There's no.
So the point was put to the judge.
Well, in the written, I've shown you how it was put. I've shown you the writing. I've shown you the oral submission, and I've shown you the way the judge understood the case to be put to him, and the way in which we understood the case to be put. What this comes down to, as I understand it, this appeal now seems to be the suggestion that there's one particular image looking at this shoe from above, or this boot from above. It now looks more diamond-like. Now, that wasn't a submission that was put in this post-sale environment, nor could it be, because the reality was what they were doing was they had a whole variety of particular types of shoe with particular types of logo on and particular images. And they were giving the judge, as I said, the appendix examples, and then asking him to use those as being representative, and the images which appeared on the Amazon page as being representative, which they particularly relied on, and then asking him to come to a conclusion in relation to that as to whether it would be likely to be perceived to be a similar sign. And he did that. He hasn't written out every single visual inspection that he hypothesized or actually put to him, but his error is not an error of not considering a post-sale environment. He considered a post-sale environment and he rejected their submission. That's not an error of principle, it's something they just don't like. Yeah. And the other point, rightly put by my learned junior, the post-sale environment cannot be considered to be just one view by one customer in one particular angle. If you're going to look at the post-sale environment as a fair and objective measure, you've got to look at in a hypothetical world, because this is purely hypothetical. There was no evidence post-sale of these marks ever being confusingly similar, or evidence of use other than the specific evidence that we've seen in relation to the Amazon pages. You've got to consider the what is a realistic environment post-sale. Do you see it just from one angle? That cannot be the right test in relation to this. So if my learned friend criticizes him because the judge hasn't specifically said, well, I consider if you see a post-sale environment, the shoe from a particular vertical view looking downwards, that would be an incorrect challenge anyway, because it cannot sensibly be submitted that the post-sale environment is only from a view downwards. You've got to take into account all realistic uses. And what I'm going to show you in a moment is that actually what is so enlightening about the Amazon pages is you see the shoes in all various angles. You see all the perspectives. And the very same point that my learned friend is now trying to make on the post-sale confusion point, namely that you would see the DP logo more as being flat double diamonds, was a point that the other side was submitting in relation to all the Amazon pages. And the judge rejected that. And he was entitled to reject that. And for the same reasons, he's entitled to reject it in relation to post-sale confusion as well.
So, can I just tell you something that's bothering me at the moment? This word square.
Yeah.
And diamond.
Yeah.
Judgment characterises the difference in the shapes as one is squares and the other is diamonds. But if a square is on if a shape is put on a point, and I'm holding up my hand.
Yeah, sure.
And of course my fingers don't make a square, I know that. But if I put a shape on its end, yes, that's a diamond. The fact that 90-degree angles in it doesn't stop it being a diamond. So I'm just worried whether characterising, by using the word square to characterise one shape as distinct from diamond. Now he also says elongated diamond, and that's obviously entirely fair. But is it fair to characterise one diamond shape, which is points on its end, and the other, but characterise it with that distinction?
Well, it's 90 degrees point, my lord. And the Umbro double diamond clearly doesn't have a 90 degree angle.
Absolutely.
And so what the judge was considering was that the average consumer would perceive, in all scenarios, Amazon and post-sale, that despite the angles at which you perceive these things, you would perceive it as being a sign which has a 90 degree angle.
Is that what he says?
No, well, that's the gist of what he's saying, isn't it? Because he's saying...
I don't remember seeing any reference to 90 degrees, but I may...
Well, it's the square with the P. So so it's 141, my lords. This is my submission in relation to what he means by a square with a P form in the middle.
Yeah.
So that's his conclusion.
Yes.
He's hypothesized, he's had actual, in front of him, images of the various angles and perspectives in relation to the Amazon pages. And he's being asked also to consider hypothetically the position post-sale. And he's done that. And in both scenarios, he considers them to be the shape which every consumer would perceive from them. One which is square, by which it means has 90 degree angles in relation to it, rather than something which would be an elongated or flattened diamond.
So he could have said a 90 degree diamond.
He could have, but most lay people would not probably. The point is not a diamond is long. The point they try to make in wording, in geometry, is it's a rhombi. They're both a rhombus. Yeah. And both are rhombi. Yes. But the fact that
both diamonds, aren't they?
I don't know geometrically that's the correct definition of that.
Well, that's what I've just been wondering about. It's never occurred to me till this moment that a shape which is a diamond shape would not be a diamond because it had 90 degree angles.
But with my respectful submission, this sort of analysis is not a fair analysis of what the judge is doing. He's fairly setting out in relatively lay rather than precise technical terms what he depicts and describes.
You might have said to overstate the difference between the shapes and give them a different name. In fact, another way of putting them is that they're the same kind of shape, which is a diamond shape. One of them has different aspect ratio than the other one. That's true, but they're both diamonds. That's why I'm worried about it, because it's because these cases are all about how do you characterise in words something which is a picture.
Yes, but what I'm suggesting is that his reasoning is sufficiently clear that what he's describing in words is something which you can see visually, obviously, on the images that are in front of you, and is a fair characterisation which allows the average consumer properly distinguish between the two, and in his view, thinks that they always would distinguish between the two.
Thank you.
Just when we're looking, I'm just looking at the beginning of the judge's judgment, where we see the mark and the sign. And at paragraph 12, there's the green hairs mark sign.
That's right.
And I mean, that you might thought could easily have been described as a diamond with regular sides.
Well, maybe it could, but the judge doesn't. He calls it a square.
I'm not making any point about it.
No.
I just thought it. When I heard
Yes.
observations,
Yes.
I just turned back to look what the registered what was seen at registration.
I'll go for my lady.
And that's what was seen at registration.
Yeah.
And I can quite see that. I mean, the judge could have called it a diamond with regular sides, or he could have called them both diamonds, one of which had elongated sides.
Absolutely.
You're saying that was how he chose to characterise it, and he couldn't be criticised for it because it still was an accurate description.
Exactly. He hasn't gone into error by the way in which he's done the description, and nor has he gone into error in terms of analysing how those signs could be used. He's considered all three possible scenarios. And he's been entitled to come to the conclusion, he did, that in relation to each of those three scenarios, the DP logo would still be perceived as, in the language he uses, tilted, round, cornered, broken square with a P form in the middle.
Well, I think we have your submissions.
No,
I mean, I don't want to interrupt you.
No.
I think you're very clear about your submissions about the way the judge approached the post-sale analysis.
I'm grateful. And perhaps, given where we are, I've been jumping around my notes a little bit, but it may be of use just to try to wrap up the post-sale submissions in totality at the same time, given I've slipped into them, which we've addressed in our skeleton at paragraph 78 through to 80.
Thank you.
And I want to make quite clear, because I'm slightly concerned that my Lord Justice Arnold thought we were contesting that you couldn't have post-sale confusion as being...
I don't think that's the case.
That's not.
Clear that you didn't take any issue on the law.
Exactly.
No, the law effectively is agreed.
Exactly.
It's agreed that the judge, in some form or another, addressed the issue of post-sale,
Absolutely.
and the appellant says he got it wrong in principle and in his application of the law and the facts, and you say absolutely not. When you take it through, this is a case all about someone not liking the outcome.
Absolutely. My lady's
And that's where I've got to anyway.
And you're absolutely right. And can I just make good in terms of the approach he took in terms of looking post-sale to show that he applied all the right principles, even if my learned friend doesn't like the answer. And I could just run through that very briefly. Could one take the judgment again, please, my lady, and start, and my lords, start at paragraphs 1 to 7, 1 to 8. So the judge has correctly identified there the average consumer and the level of attention. No challenge to that. And there's no challenge to the fact that that level of attention would be the same post-sale. The judge then considers the similarity of what has been called the double diamond marks on the one hand and the DP logo on the other post-sale, as I've just been showing you, 137 and 141. And he's still, and that analysis doing the mark for sign comparison, he comes to a conclusion about the similarity. He says not similar, there are similarities, the conclusion of 142. Still a degree of similarity, but only a very low degree of similarity for the reasons he explained in all uses post-sale. At 150, he addresses the context. Context starts at 144, but he addresses the context in relation to post-sale, specifically at 150, and says, I shall return to post-sale below, and he does, and we'll come back to that and show you it's 162, which I've just shown you. He addresses actual confusion at 151. And again, I apologise for sounding like a cracked record, but there was no evidence of any post-sale confusion in this case, no evidence of post-sale usage in the UK at all. But his conclusion in terms of...
Sorry,
sorry,
you say no evidence of post-sale usage.
post-sale...
Just as someone who, obviously, as you all know, this is not my area of expertise, but would the information we've got about the number of shoes that were sold into the UK, is that not evidence of post-sale usage, or have I fallen into
I
another
overstepped.
trademark trap?
In terms of numbers, you're quite right, my lady, and I overstepped. But you've got no evidence of post-sale usage leading to confusion.
All right.
Sorry, thank you. Right. And in fact, there was, other than sales figures, was there any other evidence? Maybe 1 or 2 images. There was no direct evidence, I understand, at all in relation to post-sale at all. It's
all those feet wearing them.
Yes, exactly. Again, I not sound like that, but this was a case that was predominantly based on point of sale and Amazon. But in any event, the judge deals with actual confusion, and he's equal-handed about it. So the fact there's no evidence doesn't lead me one way or the other. So that he's probably taken actual confusion or absence of that into account and taken a view on it, which is neutral. He then does the global assessment. 152 applies both to post-sale as it does for point of sale. So does 153. So does 154. So does 155. So does 156. 157, he starts to address Amazon point of sale with and without context. And that goes on to 158 and 159. 160, he then directly applies all the relevant elements to the position post-sale in relation to post-sale confusion. As I said, 161, he comes back, he addresses the possibility of indirect confusion, but that's there's no challenge on that, so this court doesn't need to consider it. And then 162 comes back again and looks at post-sale confusion and expands on his reasons. So we do say that this is something which is a standard and correct approach in relation to all the analysis. He set out the right law, he set out the right approach to it, and he just came to a conclusion which the other side don't like. That's not an error of principle, and it's not evidence that he's wrong. Now, with that, I can then deal, I think, relatively rapidly with the other points which I need to address on the grounds of appeal. So these go back to ground 1.2, the third aspect, which we've addressed in our skeleton at paragraphs 55 to 57, that the judge took an inconsistent treatment of the average consumer's perception of the sign. And this is the contrast between my learned friend saying that the judge noted that the DP logo had an atom element with a break in it, and thus would be perceived as a broken, slightly rounded off square at paragraph 138. But then noted in 140 that in some presentations of the DP logo, the consumer would not notice a break in the outer figure. And they say that's an inconsistency and an important one. It's not. May I ask you then to go back to the judgment again, and you'll see.
Well, you just said that it's unfortunate use of terminology, and the judge addressed it in his PTA judgment.
Yes, there's a little bit more than that, my lady. You'll have seen that in the judgment at 137, the claimant argues that sign is not always presented straight on to viewer, and in some images with angle, the shot could appear rather more elongated. The claimants also submitted that the view of the sign would not always be able to see the break in the outer shape. So it's important to appreciate that they were making two separate points, which the judge was addressing. And what the judge did was address the first of those submissions in 138, and then address the second of those submissions in 140. And so in 140, he wasn't so in 138 he's considering the angled presentations, and in those he found that the average consumer could still perceive a break in the outer figure. Again, something he was entitled to come to. When my lady and my lords have at the same time, say, page 92 to hand of the judgment, you'll see, for example, the green shoe at the top at an angle, and you can still see the break in the outer square at top right-hand corner, for example. At 139, he also emphasizes in relation to his first point about seeing the break in the square, that on the Amazon pages, there were a series of photographs, and that they showed the shoes at various angles. And he might find, as a matter of fact, again, which he was entitled to do, that the average consumer would review them all. But even without reviewing them all, he still came to the conclusion the average consumer would see the break. The point he's addressing at 140 is a different point. It's a second submission, namely that in some images you can't see the break. And the judge was right about that. Again, if you go back to page 92, and you look at the lower right image of the blue and pink football boots, in those, because there's a blade of grass going up, that you cannot see the break in the outer frame or square. It's obscured. So Iconix were right, and the judge was also right, to say that there were some examples in presentation in which the figure would not be noticed. But the judge was right and entitled to continue as he did in his judgment, to say that even in relation to those types of use, the average consumer would still see the P-like element in the central form, and that was something which the judge was entitled to rely on as being something which would be materially different as compared to the perception of the average consumer of the double diamond logo, such that they were still sufficiently unlikely to give rise to likelihood of confusion. But again, this is island hopping, my lord, my lady, and my lords, because the context of this particular use, this one you can see in the bottom right-hand corner where that blade of grass is outstanding, comes from the particulars of claim that my learned friend relied on, and that is at tab 7, at page 145. This is actually the context of the alleged infringement, where you get to see the logo being presented in a variety of different circumstances. Not just simply on that one image which you see in the middle of the page at 145, which has been cut out and placed on my learned friend's closing submissions, which the judge fairly took, saying this is your best case. So, as a matter of fact, the average consumer seeing this, even in these circumstances, would not have seen the logo always obscured with the outside square removed, the outside square being confused. Sorry, being obscured. Now, even taking that into account, the judge also, though, considered, when I said in 141, he then goes on and considers the post-sale use.
We've looked at that.
The next ground is the fourth of his, my learned friend's 1.2 grounds of appeal. This is the alleged incorrect focus on the distinctive and dominant elements. And we've addressed this in our skeleton argument at paragraphs 58 through to 60.
I don't think we need anything in addition to what's in your skeleton argument on that, do we? Did you want to go into more detail than we have there in relation to that?
What I would just do is, insofar as it hasn't been seen before, is go to tab 6, if you would, the permission to appeal judgment, and ask my lady, my lord, to read paragraphs 44 through to 45. And you can see picking it up about 5 lines into 44. In that passage, I was addressing using descriptive language the degree of similarity between the marks and the sign. I was not using those words in the technical sense as suggested by the claimant, not intending to address the kinds of arguments that might arise in relation to some composite signs or logos. I fully understood that the sign was a simple shape and not a composite one. I was explaining in ordinary language the degrees of similarity or differences between the marks and the sign. And the claimant's case at trial was there was a high degree of similarity. My conclusion was that there was not, and one of the things I pointed out was a distinctive shape, including a P-like shape in the middle. I was not saying anything more than that. And again, something he was entitled to come to, and there's no error of principle or law, or nor is he wrong so to do. That leads me to ground 1.3, the alleged irrationality. I'm not sure has been pushed or is being pushed, but I understand he didn't make any oral submissions into it in relation at all. But what it really comes down to is Iconix complaint that the double diamonds mark and the DP logos are only faintly similar, and they want to say that's wrong. They want to say that no, they were. What level of similarity?
My recollection actually is that Mr. Malinich did mention this point orally, but he didn't elaborate it because his submission is there is similarity, you see it, and there's nothing more to be said.
Right. Well, if that's the case, then obviously I make, I think, 6 points, then, my lord, and my lady, my lord. One, the judge set out the correct legal test in terms of trying to consider similarity. That's the judgment, paragraph 35, specifically relying on Spear and Singer. Paragraph 60, sub 1 of the Court of Appeal and Lord Justice Floyd's judgment as it then was. Secondly, we say that the judge's reasoning in his judgment between paragraphs 131 to 142 were clear and logical and addressed all the evidential points that were raised before him. Thirdly, the conclusions he came to in judgment 142 clearly had regard to how the average consumer would perceive the double diamond marks and the DP logo as a whole in the various presentations relied on by Iconix, both in the Amazon context and the post-sale context, and applied an overall assessment whilst pointing out how each would be perceived. He was entitled to come to that conclusion on the matters before him, even if another tribunal would have come to a different conclusion. It wouldn't, not irrational, just because another tribunal could have come to a different one. And we say, in fact, another tribunal could fairly have come to the conclusion that they were dissimilar, and they weren't similar at all, such as you wouldn't even go on to the global appreciation test. Fourthly, the judge's approach and decision is consistent with the relevant EU IPO trademark and design guidelines when you're considering figurative devices and marks. Could I show you that briefly? That's in the authorities bundle, fifth bundle, at tab 43. It's page 1431. Rather worryingly, when one looks at the authorities bundle, if you start at 1430, it says obsolete. And think, oh my word, it's obsolete. It wasn't obsolete as at the time of the judgment. This is what you'll see is the document from entry into force the 31st of March 2022. You see that from the bottom of 1431. there's a new one which came into effect 31st of March 2023, which is common ground between the parties. It contains exactly the same material and matter. So go back to 1431. When comparing signs in conflict in terms of their purely figurative elements, the office considers the latter as images. If they match in one separately recognisable element or have the same or similar contour, it's likely that some visual similarity will be found. And the following purely figurative signs were found to be visually similar, and then they give two examples, the M-type logo, which you see, and then the star within a circle. And then you'll see the ones which are dissimilar, which were, while they have the same concept, the bird flying, they don't have any element the same or similar contour, such as give rise to a likelihood of them being visually similar. So here we say using a geometrical shape per se does not lead to visual similarity per se, unless at least some components may be perceived to being identical. And we do say here that Iconix have not identified a separately recognisable element which they say matches. It's just an assertion these are similar. So it's not surprising that we say that the judge came to the conclusion that the family is similar but only faintly similar. The judge's approach is also consistent with the decisions and principles applied in the general court when making a mark for sign comparison with devices.
Wait, is this your number 5?
This is also an authority. Sorry,
sorry.
number 5, yes it is. You are quite right. I apologise.
No,
Number 5,
not at all.
yes. You're quite right, my lady. I was going too fast.
No,
Number
not at
5, and this is also an authorities tab, authorities bundle 5, tab 31. I was going to show you by way of example. Julius Summon and the Maharishi Vedic University, and you will see the two signs in question at page 1224 and 1225. And I think it's very briefly turn to paragraph 20 of the judgment. Comparison of the signs. It's settled case law that two marks are similar when, from the point of view of the relevant public, they're at least partially identical as regards one or more relevant aspects, namely visual, phonetic, conceptual aspects, and so forth. Now, again, we say there was no visual identicality in relation to any component, and the judge was entitled, when viewing the marks and the signs, to come to that conclusion. And therefore, if anything, he was generous when he said they were only faintly similar. And sixthly, and finally, we say it's not irrational having regard to the decision of the Board of Appeal in the Iconix own case, where they're seeking to oppose the Dream Pair's logo on the basis of Iconix's own double diamond flatter mark. And in that case, the Board of Appeal held the mark and sign to be dissimilar, such that they didn't even need to go on and consider a likelihood of confusion at all. And that you'll see in the authorities bundle 5 at tab 35. And you'll see the DP logo, which was being applied for at 1261. It's the same logo we've got in this dispute. You'll see the double diamond Mark II at paragraph 5 on the same page at 1261. The arguments that Iconix raised to say that the owner got it wrong and that the Board of Appeal defined there's a similarity.
So sorry, can I just pick up on what you just said?
Yes.
Am I right, therefore, in understanding that Mark I is not relied on?
Absolutely, there's a Mark II. Yeah, that's right.
So how does this help us with regard to the comparison against Mark I?
Because as my learned friends accepted, the average consumer will have the same conceptual, same visual understanding and appreciation of Mark I and Mark II logos being the same, namely elongated diamond.
But they are objectively different.
Yes, and he then accepted that as he submitted in his reply, he says that the average consumer, though, would not see those being material differences. And that's the case which was put in the pleadings and which my little friend accepted to you orally.
Yes.
So, the Board of Appeal made a comparison at paragraphs 21 to paragraphs 21 to 23. The Board of Appeal sets out the legal tests which need to be applied when you're considering the comparison of the marks, and we say materially the same law should apply here. At paragraphs 24 through to 35, the Board of Appeal then does the analysis of the similarity and is addressing materially the same arguments that my learned friend makes in relation to the comparison in this case. Paragraph 27, we say, is of import. Overall, visually dissimilar, as only have the following characteristics in common: four-sided geometric shapes resembling diamonds and rhombuses, and feature shape placed within the inner shape surrounded by a frame of sorts. But the differences are numerous. Diamonds and rhombuses, different shapes and sizes, are made up of lines of different thicknesses. Only the DP logo has right-angled corners. The inner shape of the double diamond is symmetrical. The inner shape of the DP logo is not. The outside frame with the double diamond is continuous. The DP logo, it's not, rather has a break on it, it's open. And the DP logo has an at symbol, or as the judge called it, a P-like shape in the middle of the, and the double diamond has no element, which would remind the public of the shape symbol. And again, materially, these were the same features that have been relied on by both parties, for and against, at trial for the judge as to why the sign was similar or dissimilar. At 28, the consumers are capable of perceiving differences between the stylization of the signs. Key point is how the signs issue are normally perceived overall, and not how the stylistic differences between signs may be perceived in the event that a particular meticulous consumer is in a position to examine the graphic stylization and draw a comparison between them. Again, the same law. 28, you see the second part. It's a well-known fact there's a widespread market practice for a myriad of retail manufacturers to apply simple stylized figurative elements on the outward side of their products, bags, shoes, so forth, in order to simply embellish them or to serve as designation of origin of the goods in question. The relevant public is accustomed to navigating a market in which variations in simple figurative elements play a decisive role in their ability to distinguishing different commercial origins. That again is something the judge specifically had in mind and addressed in his judgment at paragraph 153. 29, it follows, in the present case, the visual differences between the marks are so manifest that their perception does not require any substantial degree of meticulousness and effort to be employed by the average consumer. Considering the market realities in which the goods in question reside, these differences serve to neutralise the limited coincidences between them, namely the fact that they're both diamond-shaped and feature elements within a frame. For sake of 30, for sake of it, the board deems it appropriate to add at least a non-negligible part will recognise the T shape. 32 points out that purely figurative signs are not pronounced, so they can't be compared phonetically. Exactly the same approach taken by this judge. Conceptually, at 33, the signs are meaningless. A letter is conceptually meaningless. Again, the approach taken by the judge in this case. And 34, therefore, the conceptual comparison is neutral. And conclusion at 35 is that the conflicting signs are not similar overall. The overall impression is so far removed from each other that the relevant public would perceive them quite differently. So that, I'm not relying on that as being binding on you in any way. What I am relying on that is that that's a tribunal, second tribunal, because OM did the same thing, which is considering effectively the same material, the same law, and coming to a conclusion not only that these are not similar, they're dissimilar, so you don't even go on to the likelihood of confusion test. And therefore I do play that in aid, but how can this judgment be rationally unsupportable when two tribunals have come to a conclusion which is even more extreme than this judge, applying the same law to material identical facts?
I thought you weren't advancing the argument about the P shape, which seems to be a critical part of reasoning in this judgment.
Not critical, but it's an element which I take it out. But it can't be an element which takes into account the point which my learned friend is saying, which is that it has some conceptual meaning, because the court then rejects the P has any conceptual meaning.
Yes, sorry, maybe I didn't express myself properly. And may I, if I'm misunderstanding the Board of Appeals judgment, do tell me, but as I read paragraphs 30 and 31 in particular, they place specific reliance, describing it as particularly important, and it's reminiscent of a P. But I thought you were not advancing that.
I'm not advancing that. But what,
There's an aspect of this reasoning which is important to the reasoning of the Board of Appeal, which would enhance the dissimilarity, but you're not relying on that.
but that's only to some customers, not all consumers. You see, it's a subclass.
Yes.
So it's not saying in relation to, so it doesn't apply across the board, my lord. My lord's quite right. There's a subclass which is even less likely dissimilar, but applying to all the average consumers, they are dissimilar. So my lord's quite right in the specific subclass, but that's why I lost it. I apologise. And this court will be aware that before the trial judge, obviously, Dream Pair's submission was that the marks should also be held to be dissimilar, so you didn't get on to likelihood of confusion. But a likelihood of confusion taking into account the global assessment. So we do play in those 6 points in support of the fact that this is not an irrational judgment.
Just on that last point,
Yes.
what do you say is the relevance of the fact that the catch word for the decision, as one sees from the gutter of the typography, is device of a slanted letter P surrounded by an almost complete square?
Well, I say I look at the reasoning, my lord, and the reasoning is what was the reason for the decision, and that wasn't something which I've addressed my lord Justice's first point about that. The P thing was not material to the ratio of this decision.
Yeah.
I apologise. That then leads me to ground 1.4 of my learned friend's appeal. And as I understand this in his written, sorry, we've addressed an articulation argument at paragraphs 68 to 70, my lady and my lord. My learned friend didn't rely on this orally, as I perceived it. I may have got it wrong. In writing, they seem to suggest that the judge erred by relying on Umbro's actual use rather than notional use of their double diamond registrations. And in writing, this seems to include at paragraph 62 of their written submissions, that if the judge had considered the notional use, he would appreciate that the double diamond marks would be perceived by the average consumer as squarer than as the registered mark. We, from our side, find this submission both illogical and confused. The double diamond registered trademarks have in fact been used in a variety of clothing and footwear. The judge held that they had a reputation on football boots, football kit, and performance wear. That's the judgment at 75. The judge saw evidence of the double diamond registered trademarks being applied to clothing and shoes in a way that the average consumer would be accustomed to seeing them from various angles. Iconix haven't identified any potential nature of nominal or notional use, which the judge has said to have failed to take into account, even on Iconix's case, that would mean that the marks should be considered to be perceived as squarer by the average consumer than how in fact they were perceived. Rather, in our respectful submission, there seems to be a general nitpicking complaint or whinge that the judge should have given more weight to the fact that the marks can look like squares from some angles, but this is the point the judge addressed squared on with the submission and rejected it at judgment 132 and 133. If they're making separate points on the failure to take into account notional use and one on the failure to give weight to the fact that the marks can be seen from angles 2. Both those are wrong. There's nothing, we say, to suggest that the judge failed to consider the notional use. And again, Iconix haven't identified what difference would have made. The point about the average consumer potentially perceiving the marks as squares, it was unrealistic because they would also see them side on. It's also contrary to the evidence and the pleaded case, which stressed that they were diamonds and would be seen as such. And I think we have about 4 points in relation to this. Firstly, the judge correctly set out the test he must apply. That's the judgment at 37. It's the actual use of the sign, the DP logo, as against the mark as registered. Again, Iconix, as I understand it, accepts that's correct. He analysed the marks as registered. I've shown you that. It's 132 to 133. He noted that they were described as a matter of fact in the claimant's internal marketing as double diamond. That's a judgment 132. That's not suggested to be wrong, nor is it challenged on the appeal. The judge addressed the submission that a significant number of people with characteristics of the average consumer would perceive the marks as an isometric view of flat concentric squares, and he disagreed with that. That's at 133. He considered that effectively all consumers would perceive the marks as flat elongated diamonds and not as tilted squares, a judgment again which he was entitled to come to and which has not appealed. Now, that decision was also, firstly, in accordance with the way in which Iconix pleaded its case, which was to describe its mark as being a diamond logo. And there are a number of references, but I'll just take you to one, if I may. And that's in the reply, again, at Core Bundle tab 9. Page 161, paragraph 9, and specifically at 9.2.2, the DP logo and the marks will all be perceived to consist of or substantially to consist of two concentric diamond shapes. That was their submission in relation to their marks. It's in accordance with the evidence which the judge noted both at paragraph 132 of the judgment that they were referred to as double diamond. And to make that even clearer, my lady and my lords, could you look at the supplementary bundle and turn to tab 4, please? And turn to page 151. Paragraph 54, the submission was that no, that they wouldn't consider them being isometric views of flat concentric squares. The evidence, though, which was relied on, you can see at 50A, 54A, B, and C, 2009, Umbro Creative Centre, the brand guidelines, one of the logo rules is that the Umbro logo should never be distorted, stretched, or squeezed or condensed. The following image is noted as an example of what not to do with the logo. The brand guidelines in B, 2016, for the mass market retail document, Iconix again said that stretching its double diamond logo either horizontal or vertically was an instant red car event, and the Umbro marks were referred to as the double diamond and internal marketing materials in both the two factual witness statements of Umbro, who gave evidence before the trial judge. The third wrap-up point of that is the judge had that specifically attuned to that because in his judgment at paragraph 23, he also says that that's how the claimant's own witnesses referred to their two registered trademarks. And fourthly, it's notable that there was no evidence, despite the very, very, very long use of the double diamond mark, that anyone had ever perceived the double diamond registered trademarks as being an isometric view of flat concentric squares. That was purely a legal submission brought up by the clever lawyers on the other side. Similarly, insofar as there's notional use, the judge considered the registered trademarks in respect of all the goods for which they were registered. You can see that from the judgment at paragraph 6, he set out the goods for which the registered trademarks were registered. He was fully aware that the scope of the registration was wider than just football boots, because he had to make findings of reputation in relation to the marks. And he did that specifically at paragraph 63, 64, 72 to 75. And he found that they had a substantial reputation for football boots and kit, less reputation for performance wear. And at 129 to 130, the judge noted the identicality of the goods upon which the sign was being used by dream pairs, footwear, not limited to football boots, the common ground that the DP logo was being used on various forms of footwear, including women's fashion shoes, which are wider than just simply the shoes upon which the double diamond logo is being used. That's the judgment at 92. And he clearly had all those points in mind when considering the global assessment, particularly paragraphs 153 and 154. So on our respectful submission, we cannot understand what possible basis it can be said that the judge failed to take into account the notional use of the marks as registered, but only consider the marks as used in relation to football kits. And similarly, we can't see there's any legitimate basis for finding that the average consumer would perceive the marks as being effectively anything other flat elongated diamonds rather than tilted squares when you're considering nominal or notional use as opposed to, in fact, even the actual use in which they were used. So that we say is the end of that ground 1.4. And then in relation to ground 1.5, there were 2 points. I've dealt with the post-sale confusion. The other point is context and the suggestion the judge improperly took into account material extraneous to the mark. This was at the point of sale in terms of Amazon. My learned friend didn't push it. I'm not sure whether he's still pushing it or just simply right now on the post-sale. But insofar as he did, we say that the judge did not fall into error. There's a very short answer to this, is that the judge made his findings both in relation to the contextual matters which he took into account, and also then said, even if I didn't take those contextual matters into account, I would still have found on the outcome of the multifactorial assessment that there would be a likelihood of confusion. Can I show you that at judgment 159? So he does his global assessment, as I was taking you before, on page 85 of the bundle, and he considers at 157 the context on the relevant Amazon page tends against confusion, and it shows because there's a Dream Pairs as a separate brand, and because there's no mention of Umbro or anything else to link the two brands. They're the two contextual points he has in mind, which push it against like no confusion. Then on 158, and then 158 says, therefore makes it a global assessment. I'm not satisfied there's a likelihood of confusion amongst a significant portion of the public. But 159 says, for the avoidance of doubt, I would have reached the same conclusion, even ignoring the contextual information on the Amazon page for the relevant footwear, including the references to Dream Pairs of the brand and the absence of reference to Umbro. And so, with respect to my learned friend, this is again a hopeless argument, because to suggest that the judge fell into error because he took into account contextual matters which were illegitimate and was expressly addressed by the judge in two ways. Both, I'm entitled to it, but secondly, even if I got it wrong and I'm not able to address those matters, I would still come to the same conclusion. So the retort is that the judge improperly failed to give any reasons for that conclusion. Could I ask you to turn behind tab 6 to the permission to appeal judgment? And that, if you look at page 101, paragraph 52, I explained in paragraph 159 of my judgment that I would have reached the same conclusion even ignoring the contextual information on the Amazon webpage, including the referencing to Dream Pairs as a brand and the absence of reference to Umbro. The claimant contends that no adequate reasons have been given for this, but I do not think that there's any real prospect of an appeal on this basis. It's clear from the remainder of the judgment that I took into account all of the relevant factors in reaching an evaluative multifactorial assessment. And the point I was making was that I would have reached the same conclusion, leaving to one side the context which I referred to earlier. I set out the various factors which I took into account in reaching the overall assessment. That's not an absence of reasoning. And in any event, the reasons which he gave in his original judgment, we say, were sufficiently cogent anyway. If you go back then the tab to the original judgment, I've shown you already that the analysis starts at 152. But all of those points, 152, 153, 154, all correctly identifying the interdependency period principle 155, pointing out significantly different character. 156 notes as between the marks only very low degree of similarity. Then he takes the context 157, finds a global likelihood of confusion, not satisfied at 158, same reasoning at 159. But if you then go on at 160, again, he says in terms, I've reached the same conclusion in relation to post-sale confusion. The claim accepts the degree of attention to be the same. A potential consumer who saw someone wearing huge branding with a GP logo would not, to my mind, confuse them with the marks. I've explained the difference between the sign and the marks, and I consider these would be apparent. Someone with characteristics of the average consumer who saw the relevant goods. I do not think there's any material between the case and the pre-sale presentation. That's what he's saying there. He's saying absent context, in the post-sale environment, he wouldn't find likelihood of confusion. And so he's saying the same thing in relation to the contextual position in relation to Amazon. He would have come to the same conclusion, even if he didn't have the contextual information from the Amazon pages. So with respect to my learned friend, the judge did give reasons, and the reasons are that in his view, the average consumer would not be confused because the mark and the sign are not sufficiently similar in respect of those goods which has been used by the average consumer, which has been found by the judge to be the relevant average consumer, bearing the relevant attention to give rise to a likelihood of confusion. So the judge was entitled to come to these conclusions in any event. I can go on and say that the judge was even entitled to take into account what my learned friend says in his written submissions, but not orally, are relevant contextual matters. I don't know, my lords, my lady wish me to hear on that, but if you do, I can address you on that. But the short answer is that in light of Specsavers and my Lord Justice Arnold's judgments in Jack Wills and Europe Carr, my Lord Justice Birss decision in Thomas Pink, and as accepted by my own friend in his oral submissions to you today, the context is wide because you are entitled to take into account anything, all the circumstances of the use that are likely to operate on the average consumer's mind in considering the sign and the impression it's likely to make on him. And my lords will know that and the detailed analysis of Lord Justice Kitchen in Specsavers at 76 through to 87, and the particular examples at paragraph 88, where you see all the context which is taken into account, so that you take into account not just simply the particular use of the sign, but you see you've got to take into account the posters, you've got to take into account the strap line, you've got to take into account the store leaflet. Likewise in O2, you've got to consider the whole advertisement. Likewise in Jack Wills, you must take into account the fact that the infringement is using, or the alleged infringement is using a band, linear, which is a House of Phased band. It's sold in a distinct area. All the goods bear those labels or swing tags, and that the defendants didn't sell Jack Wills clothing, and there was a different age profile and so forth. So all of those matters have to be taken into account in the context. And the judge did that in relation to the Amazon context. And the two particular factors that he well, when he did it, he set out, first of all, he set out the correct legal test, which is at paragraph 39 of the judgment, setting out the passage of Lord Justice Kitchen in Meyer, which the learned judge then requoted himself from Specsavor. He applied it to the facts, and you see that at 94 to 96 in terms of presentation at on Amazon. And then at 146, in the context particular, he says he's already explained those parts which I've just referred you to at 94 to 96. And then at 147, they identify the brand as Dream Pairs. Just so my lady and my lord have this clearly in mind, the particular images which, for example, the judge is referring to and were pleaded in the particular claim can be seen at tab 7, for example, page 141. Where you see the boot with the logo on, you see on the left-hand side all the various images of the boot, which the judge held, as a matter of fact, would have been seen by the average consumer. You see in the top right-hand corner of the image that the brand is described as Dream Pairs. And you see at the bottom of that page, both the Dream Pairs name and also the logo. And so at 147, the judge is right on the facts before him that the context included that the pages identified the brand as Dream Pairs, and that the pages also didn't include any reference to Umbro. And he addressed whether or not those are relevant at 148. Seems to me, when considering likelihood of confusion, it's potentially relevant to the perspective of the average consumer that the goods in question are branded as something other than the marks. That's something that's going to operate on their minds. Of course, there may be questions of sub-brands or collaborations, which he then goes on and addresses. But leaving those to one side, it appears to me that the relevant context of the brand of the goods are identified as other than the registered mark, at least where the average consumer would associate the mark with a known brand name. I find as a fact that the average consumer was aware of the marks, i.e. the double diamond marks, and would make a mental association between the marks and the Umbro name. That's a matter of fact he was entitled to find, especially on the evidence presented to him. I base his conclusion on the evidence about the high levels of distinction of the marks and the substantial fame of the Umbro brand in connection with their use. The average consumer will not simply see the mark and think it's had something to do with an unknown brand. They would think of the Umbro name. In other words, I do not think there would be a significant portion of the public who were aware of the marks who would not make the association with the Umbro brand a name. The average consumer would notice of evidence in the Amazon page to Dream Pairs and the fact that it says nothing at all about Umbro, and support for the view that branding of allegedly infringing goods is potentially relevant, part of the context we found in the decision of Mr. Justice Arnold and Jack Wilson, 97 and 98. Again, applying. So these were relevant factors which he was entitled to take into account as part of the context at the point of sale. He did, and he put them in the pot. It doesn't necessarily mean there will inevitably be a likelihood of confusion during the global assessment, but they're factors which he was entitled to take into account, and he did take into account. But even, his judgment then goes on to say, even putting those out of the pot, he would still have come to a likelihood of confusion. So we say there's no error there, either as principle in terms of the law, in terms of the application of the law, in terms of the conclusion he came to in terms of the use of the context in Amazon circumstance, nor can it be when he's then excluded that from his consideration and still came to the conclusion which we say he was entitled to come to. And just so this court is in as good a position as the court, the reason these shoes are floating around the courtroom is that the judge was handed up, I think, five instances, which should be in court here, of the shoes containing the DP logos in various positions. And this was, in a sense, the best evidence from which, in my respectful submission, the judge was able to make any post-sale analysis in terms of looking at these from above, along the lines of my learned friend. They're here, if this course would wish to be in the same position as the judge, I'm more than happy to hand them up for the court to have them by writing judgment.
I don't think we need 5. I think one or two will probably do. So why not give us the green and the black and red? Yeah, just the 2 in your left hand.
Oh, so just those 2.
Yeah, that would be quite sufficient, I think. Thank you.
Unless I insist you further, those are sufficient.
No, thank you very much indeed. Anything in reply?
I want to just address 2 principal topics. The first of them was the procedural position. It was put by my learned friend in various different ways. We had either soft-pedalled the issue of post-sale confusion or gave the judge all the information he needed to make a call on post-sale confusion. It wasn't very clear which of those 2 my learned friend was contending for. And then on the question of which images the judge considered and whether he considered angle of view, my learned friend misses out the all-important step. And perhaps I could start with that. There isn't a dispute that the judge had plenty of angles. He had them in the annexes, he had shoes before him. The issue was the conditioning point that I was referring to in opening, which is that if you know it's a square, then it doesn't matter what angle it's at, you're going to see it as a square. In the post-sale environment, you miss that essential piece of information. You never know that it's a square. You simply encounter it. And it isn't a defense to that point by suggesting that there may be other angles that they may see as well, or they may see it from different angles. The point is, but for the people who don't, and those are the people who are looking from any human head height, roughly standing, to anybody else wearing one of these, wearing a pair of these shoes, they are going to see a square that is elongated. And their friend really can't get around that. And that's why it doesn't matter whether there were Amazon pictures shown to the judge or whether my learned friend, Mr. St. Quintin, referred to post-sale confusion, because the judge never considered that essential point. And had he done so, in fact, a moment ago, it was said that he was given lots of pairs of footwear, and therefore he knew what things would be like in the post-sale world. Well, unless somebody was walking around in front of him, he wouldn't. But even then, he wouldn't be fairly assessing a post-sale consumer, because he himself was conditioned. The judge needed to think about.
He was a square man.
He was a square man, and he had seen things in those terms and clearly could not get that out of his mind. My learned friend regards our criticisms as being perhaps more unfair than they are. We consider we're being very fair to the judge by simply acknowledging the fact that, having seen it as a square, he continued to see it as a square, and that's a perfectly natural thing because people are prone to doing that, and the judge didn't ever step out of that guise, and he needed to do that. That really is the essential point that we would make on all of the submissions that are made in relation to the angles of view. I wanted also to address you on the procedural position. As I say, it isn't clear from our side as to whether it is suggested that you had sufficiently submitted post-sale confusion or insufficiently dealt with it, but one way or another we'd got it wrong, it seemed. I thought rather than actually grind through all of my note on this, it may be of greater assistance if I gave you some references as to the way the case unfolded on post-sale. Let's find it. So I think you've already seen pleading, but it's in the main bundle. We had paragraph 20 you were taken to, which made it clear that the aforesaid examples that were referred to earlier in the pleading, which were all about Amazon, did not limit the claim. And there's also at the point in the reply.
Well, perhaps more importantly, from your perspective, I noticed that paragraph 25.6 explicitly pleads post-sale confusion.
Yes. And this point is picked up again in the reply. Yes, will also be subject to after sale and consumers who see a person wearing a pair of the goods bearing the sign. So that's considering a position, again, wearing, presumably standing, and from that angle. The reply also deals with this. Yeah. Just a moment. So, reliance was placed upon the transcript on day 2, which was a reference to the, if you still have your particulars there, that's a reference to the annexes that were at particulars. Sorry, the annexes to the defence is what I had in mind. Yes, and then so the transcript for the reference for a note is day 2, internal page 187, lines 12 to 13, and that transcript reference makes it clear that the reference that the what Mr. St. Quintin is talking about below is limited to the photographs, or those photographs only related to Amazon. Now, the case, as has been made clear, the case was never limited in closing submissions, because you will have seen from the written closing that there is an express allegation of 71.5 of the post-sale confusion there as well. And the My Learned Friends oral closing, again, that's in 71.3 of the written closing and 71.5 and 72 of the written closing, and you'll find those at supplemental 3, page 114. The other point about the procedural sort of objection is that my learned friend, Mr. Barclay, also engaged in a certain amount of discussion in his written closings when it came to the issue of post-sale confusion. He suggested that there was nothing to it, it was not pleaded, and various other points. We can pick that up at supplemental bundle, page 170, tab 4. And it's quite clear that there was a detailed amount of submission on this, at least in writing. And if I could particularly highlight the page 172, when it was said that the post-sale confusion argument was flawed because there's no chance that a significant proportion of consumers would see a pair of dream pair's shoes on another person's feet and then perceive the dream pair's logo in sufficient detail to rely on it. Well, that is a submission based upon an understanding of the law on post-sale confusion and on whether a transactional context is sort of necessary. For example, the only scenario in which the public would encounter the dream pair's football boots outside the transactional context is if they were on the feet of someone else while they were playing football. They would not commonly be worn in the street. There were also trainers and other shoes. And then it is said that consumers are careful and circumspect, that we can't rely on lower degrees of attention, or we don't. And then the only circumstance in which confusion might possibly arise is when it's from afar. Well, we don't rely on it from afar, we rely on it from a normal distance and from a normal height. Now, it is then said that, I noticed my learned friend didn't rely on the academic commentary, more reliance on that in the skeleton. But there is a point between us potentially on whether, I don't know if my learned friend is still taking the point, but we don't regard it as necessary that the consumer who's confused in the post-sale context, that they have to be ready to transact or be in consumer mode or any of that. So really, all of that is just there to show you that the point was clearly before the judge, and that the judge didn't, we say, deal with the essential point, because it wasn't about whether you had, it wasn't about whether it was suggested to the judge that you needed to consider angles of view. Yes, angles of view were important, but it was about whether you were a square man, whether you had actually been educated about that vital step. I just wanted to pick up on some of the other points that were made. On the point about our reply, having said or having regarded the two marks as being the same, that paragraph, which is core 9, page 160, is actually talking about distinctiveness. We said that they were both distinctive. That doesn't mean they both have the same scope of protection. They're clearly different marks, but that's a point that goes to the comparison of the marks. So far as the conceptual counteraction point is concerned, one could perhaps not spend very much time on this, but it is clear, we say, that the judge is describing the consumer perception, not just using the words as shorthand for his own convenience. There was a submission made that my learned friend seemed to retreat from somewhat under some questioning by Lord Moral Justice Birss. But as we understood the position, he was suggesting that the square appreciation or the paper-based appreciation must come in every case. You can't have a consumer that doesn't see, that you can't adopt an analysis of a consumer confusion scenario without starting with sort of black and white, perfect, crisp image, because that's part of your initial analysis. That, we say, is wrong. There's no requirement for that, and it's a quite obvious attempt to smuggle in, effectively, the perfect square at every stage of the analysis. So, I wasn't proposing to deal with some of the more secondary points that were made. Yes, the foreign decision. Sorry, there was one other point. I was surprised to see my learned friend rely upon two EU IPO decisions, even though they're in this case. And it's always tempting, of course, particularly if the result has gone your way. We're dealing with the post-Brexit. We're dealing with the EU IPO, which is a completely independent system. We've got he's got the rule of Hollington, and which is that you can't take into account foreign tribunals of fact. We've got the difference between the fact that they're dealing with a registrability case and we're dealing with an infringement case. And if you look at the decisions for their intrinsic worth, the first decision held that there was simply no similarity, not enough similarity even to go to the trouble of assessing likelihood of confusion. I mean, that's how intellectually bankrupt that decision was, in my submission. And the second decision got the law completely backwards when it came to assessing a significant proportion of the relevant public. In other words, it starts out by saying that because a non-negligible part of the public would understand that they have a different concept, that was somehow determinative. The decision-making of the EUIPO will be very familiar to two of my lords, and it is a very mixed bag. Some of it is first rate, and some of it is very quick and not very well considered. But for my learned friend to hold those up as somehow factual findings that he must rely upon, and the submission was, well, they're even crazier than my learned friend says the judge was, which is a very poor submission in my submission. So we would ask you to put those to one side. And those are my submissions.
Thank you very much indeed. Well, thank you all very much indeed. Thank you to the leader, but also to the juniors who I know conducted the case at first instance, and so had that, well, the comforting feeling of having a leader, the uncomfortable feeling of it's my case. So I'm very grateful for all the hard work I'm sure that each of the juniors put into the preparation of the case. You won't be surprised to hear that we're going to reserve our judgments in this matter. I can't tell you precisely when we'll be able to send out drafts, but as soon as practicable, obviously. May I just remind you about the terms of the embargo? I don't know how trade sensitive this case is, because obviously we don't know the background information that goes with it. But please ensure that we send the list of who's going to have access to the draft. And please, if no doubt it'll fall to the juniors yet again, just to remind everyone that there are a very limited number of people who ought to be looking at any draft judgment.
So, Major, just on that, can I just raise one point? In
Yeah,
that,
of course.
my instruction solicitors are in turn instructed by some US attorneys.
Yes.
So we will be asking you
Of
two
course.
named
Yeah, that's
attorneys.
Yes, that's
very
of course, that's absolutely fine. Typographical errors and minor infelicities, please, not an invitation to treat. And perhaps you'll be able to deal with all other matters in writing and agree an order. We'll deal with any further disputes in writing. And if you can remember, we haven't, I don't think, I mean, they may have got stuck in the office, but I don't think we've received our cost schedules. So if we could ensure that the rules are complied with in relation to those. So subject to anything else that we need to deal with today, can I thank you all and those sitting behind you very much indeed.
All rise if able.